folks, this video is going to give you a little bit more direction on how the relationship between tenants and landlords has been dealt with here in ACT. So I'm going to read a little bit of this just to make sure we get it right for you. So on the 21st of April of this year, of course, the ACT's Attorney General handed down a ministerial direction which gave effect to the federal government's mandate to the states and territories to give a moratorium on evictions to residential tenants who have been infected by the COVID-19 virus. Now, the first most important thing is we need to define what a COVID-19 infected household is. So, the definition is that one of the members of the household must have the COVID-19 virus or be a carer for someone with a COVID-19 virus. The third component, though, that is also allows them to be eligible is if, based on either a law or direction given by the state, territory or commonwealth, that their business can't operate, such as a restaurant shutting down or gymnasium shutting down. If those businesses have been affected, and that has therefore led to a tenant not being able to gain employment, then they are eligible. Now, the other component for this, though, is that the tenant actually has to prove that their income is reduced by more than 25% of what it was prior to the COVID-19. So that is an essential component of ensuring that they are an eligible household. So what does the moratorium on evictions means? It quite simply means that if that household is affected in any way by COVID-19, the landlord cannot evict that tenant. So it's a protection, of course, for tenants that they've got what would initially be a 3-month period, and then the ability to extend that for another 3 months if the government deems that to be suitable. So a possible 6-month time frame where they can't be evicted based on whether or not they've paid rent. The other thing is that in terms of rental reductions, that's been a very topical thing in the media at the moment. So yes, the ACT government says that it's entirely appropriate for landlords and tenants to be discussing mutually acceptable rents moving forward. And so that doesn't, however, mean that you can't change that rent back up to the level it was prior to the COVID-19 once this declaration is completed and once all this blows over. Also, a tenant that has, say, got behind in rental arrears and isn't able to make those payments cannot end up being blacklisted in any tenancy databases. So there's a protection there that if they get behind, they're not going to get a black mark against their name. Now, restriction on rental increases is the other part of this. You can't have a rental increase if you're a landlord into a COVID-19 infected or affected household. So that's protection there as well. And in terms of physically accessing the property, well, you can't do that as a leaseor or a property manager unless you have the tenant's express written permission, or of course if it's for urgent repairs. If you still need or want to access the property, you'll actually need to go to ACAT to get a ruling that will allow you to do that. So I hope that's helped out, folks. There's a lot to know and understand, and there's other videos we've shot that should help out as well, so feel free to have a look over them, and we'll see you next time.